Welcome to the program. I'm Mark Imperial. This segment's being brought to you by booksgrowbusiness.com. It's the place where busy professionals publish to educate their consumers, to grow their practices, and to leave a legacy. We're doing a series of spotlights on remarkable attorneys across the country with a focus on elder law and or estate planning. Joining me on this segment from Western Massachusetts is Karen Jackson. Karen, welcome to the program.
Thank you, Mark. It's a pleasure to be on your show.
I know that it's a broad topic, what we're talking
Yes.
about here. So kindly tell us a little bit about your areas of focus specifically and the types of clients that you help.
Yes, thank you. Well, I do elder law, as you mentioned. I'm a member of the National Academy of Elder Law Attorneys, naela.org, which is a very important resource for your listeners, viewers, for any elder law issues that people may have in their families to find a NAELA attorney for elder law issues. The largest chunk of what we elder law attorneys do is helping clients pay the nursing home bill, or actually, more to the point, stop paying. In my area, it's about $300 a day for nursing home care. So we elder law attorneys have amazing toolbox. Every state is different, but we know, like for Massachusetts, I have my toolbox. The big point I want to make on elder law is, if you know any of your viewers know anyone who's in a nursing home, have a family member, call a NAELA attorney. I get so many stories. Oh, after I paid $500,000 for such and such care, then now I'm applying for Medicaid. Way late. We could have saved that money.
So I understand that elder care, elder law, that is relatively a new evolution of estate planning. Can you tell us a little bit of like what triggered that sort of need in the marketplace, and what were the biggest challenges people were facing that needed the solutions?
Yeah, NAELA was kind of organically, it was organized. Massachusetts was one of the earliest states, I think was California. There were attorneys like myself. I've been an attorney since 1978, first licensed in California. And I just, over the term of my practice, I just had an affinity for my clients who were elderly, helping them. And it turned out there are a lot of other lawyers like that. And NAELA, I think, was started, I'm not sure, someone would have to look that up, in the early 90s. And I joined in 96 when I moved to my practice to Massachusetts. So I think it's a matter of like most attorneys or any profession, you just find your niche, your areas that you have like a certain feeling about. But the companion side, when you started asking me what else I do, it's estate planning. And now here's the other side. I am very big on everybody age 18 and older having what I call the big five, the core estate plan. I get calls, am I old enough to have a will? I say yes, because I can tell they're 18 years of age or older, meaning they're an adult. Or they'll say, am I rich enough? I say yes. And I can give you one example that I've seen about every 5 years in my long practice of like 45 years. A young person tragically dies in an automobile accident, and more than a million usually comes into the estate. And the young person didn't have any money and didn't think of a will, and now it's the family tree that gets the inheritance, and the young person would not have said that. Most of the time it goes to the wrong people. So I do want, so the will, even for our young people and even for people who now don't have money, if they can afford to, they're, it's a very affordable, there are lots of choices on how to get a will, but you don't want just a will. The other documents die when the person dies, and the power of attorney avoids a thing called a conservatorship, a horrible probate court thing. And in the power of attorney, the person, if they became, it's called the principal. If the person became unable to know what he or she is signing, with the power of attorney, the agent name can sign that the principal's name, and that avoids probate court. And the healthcare proxy, it goes by different names in different states. Sometimes it's power of attorney for healthcare. But if a person becomes unable to decide or communicate healthcare decisions to the doctor, the care provider, the document allows the person named to then speak to the doctor, and that avoids a guardianship. So, and then the other two documents are the HIPAA release, which allows a healthcare proxy to have access to medical records. And lastly, a thing called the advance directive, or also known as living will. I don't really like that phrase, but that's end of life issues. And I say always have the capital C conversation of end of life. I mean, it could happen. We never know, right? It's not by age.
And
So
that's different. That's different than the healthcare directive, the living will, the end of
that's a
life.
really good question, Mark. Yes. What the healthcare directive does is name the agents, but it doesn't have any kind of information about end of life. In my state of Massachusetts, it might vary in other states. The care provider is not allowed to read what was written and signed by the person. They're only allowed to listen to what the healthcare proxy says the patient wants, which I think is a very good law, because they could change their mind with a blink of an eye and communicate it. They do want to be saved. They do want to be intubated another time, whatever. So I like it. I think the hardest job of all these jobs is the healthcare person, which we call proxy in my state. Number one, that's the 3 a.m. call for the emergency room and all those, and taking to doctor's appointments and things. But the hardest job is whether or not to pull the plug. And I'll have clients say 5 years ago, fill in the blank, spouse. I've heard it all. They tend to say 5 years ago. They're still haunted. They had to make a choice: continue artificial support or allow the patient to die a natural death. They never had the conversation. So if everyone could at least have, we just had a crack of lightning here. If anyone just have the conversation. Just encourage your people to do that, because it really weighs on the agent's mind years after they make a decision.
Very insightful. I like that big five. I really appreciate that.
Thank you.
You mentioned a couple of myths or misconceptions. Am I old enough? Am I rich enough? I don't have enough. So what do I need to do? Why should I do this? Are there any other big myths or misconceptions hanging out around there that you've heard?
Yeah, I have so many. I'll try to remember some of them. People think, I have fun in my classes. I'll say, "What do you think happens if a person dies?" I could play with you. Here's what I ask my group of people: "What do you think happens when someone dies without a will?" Pass if you want to. I don't mean to put you on the spot.
I'd imagine some people think that it just goes to their spouse automatically or something like that.
You're very close. You're closer than most people. It is. It's a family tree. We lawyers call it the law of intestate succession. So it is a family tree. I call it the state writes the will. About 8 years ago, my state changed its will. So I never want my clients to just count on, whatever my state's will is at the time I pass away. And also, a lot of people, they're moved from one state to another because they have dementia, like a typical story I see in my state. People are so happy to get out of our winters and they move to Florida, but all their kids and family are behind. And then eventually when they have dementia, they come back to Massachusetts. So you never know what state, no one ever knows what state they're going to pass away in. So I like people to take control over and have a will. But back to a misconception, they think having a will avoids probate. It doesn't. Why do we need probate? Probate is the process of changing legal title from the person who died, we call them the decedent, to the living beneficiary. So someone who owns a house, Mr. Green, let's say Mr. and Mrs. Green own their house jointly. Mrs. Green passes away. Then but it's joint ownership. So Mr. Green automatically owns the home. But when Mr. Green owns a home, it's only in his name. Who do we give it to? I think probate court was invented, I'm kind of making this up, because people are killing each other over the house. Mm-hmm. And so they invented a system it's an orderly system. Probate is a good thing. Otherwise, we'd really have problems with changing title property to the living, from the dead to the living. So when I get a call from a client, they go, fill in the blank, just passed away, what do? I say, make a list of the assets, and then we go through them. There are 3 ways title property passes to the living beneficiaries. Joint title, like Mr. and Mrs. Green, that's joint. Or if it's in a trust, but then the third way is through the will. So if, so some, oh, I'm sorry, a named beneficiary is the other way too, like an IRA or something that avoids probate. So having a will does not avoid probate is the bottom line on one example of a misconception people have.
That's really insightful. And it's power of attorney that helps avoid probate. Is that right? It's the power of attorney
Power
part?
of attorney dies when the person dies, but thank you for bringing me back around. On the big five, all the other, the will comes alive, so to speak, after the person
Mhm.
dies. We use the last will they use, which they can name who's in charge. That's also a really important part of the will. One more thing, Mark, I wanted to mention on the will, where people who have young children under the age of 18, they're not an adult, they can name the guardian of their children in the will. And that's really important for our young people too. But the other four documents, the power of attorney, as you mentioned, it dies when the person dies. It's needed to avoid the conservatorship. If the person doesn't know what they're signing, that like a deed
Mhm.
or other important legal documents, their agent can use the power of attorney. Probate court for probate in the will, for probate purposes, when someone dies leaving assets like Mr. Green, leaving his house in his name alone, if Mr. Green had a will, we would file it and we would follow who would be in charge would be named in the will. And so we don't get the wacko in the family. That's a good thing. And it says who gets his house, his three kids or his best friend or whatever. If Mr. Green dies without a will, we still file a probate. We have to get his house into the name of the living. Uh, and so we'll use the law of intestate succession. And that goes with, I just have one, it's really convoluted. I have 18 heirs at law because the Mr. Green in this example died without a spouse, without children. The parents had died. Then it drops down, and I'll just be generic and say the first cousins. So that's another benefit of a will. You can name who you want, and usually you don't name 18 people. But a family tree can get very complicated.
When you mentioned probate, it inspired another thought that may or may not complicate this, but I think it'll even clarify this further.
Good, I like that.
Avoiding probate, I've heard something about creating an estate, or is
A
that what
trust.
that is? A
Yeah,
trust. That's it.
yeah, that's
Can you
it.
speak to that?
Oh, yes, I love trust. I call trusts a piggy bank. So, uh, so the client, Mr. and Mrs. Green or Mr. Green, whatever, doesn't matter. I like joint trusts. I do a lot of joint trusts, but it depends on the trust purpose, what I'm doing. But let's say it's Mr. and Mrs. Green, and they sign their trust. It's usually about 26 pages. They're usually, lengthy, blah, 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 blah. But you could put, we lawyers always go, well, while we're at it, let's keep doing stuff. You could put a trust on one page. We, Mr. and Mrs. Green, they're called the donors. It's our money, our house, our money. We declare this a trust, and we're naming ourselves as the initial trustees, and daughter Susie Q is next trustee, and then Johnny Boy is next trustee. And at our death, take care of us as long as we're alive, trustee, and then at our death, give it to the two kids. But you can do so much more.
Mhm.
You can shelter it, not from creditors in a revocable trust. But anyway, a trust avoids probate. Whatever the Greens put into the piggy bank avoids probate.
And where does that fit into the big five? Is it
Yeah,
set totally separate?
it is totally separate. Boy, I love your questions, Mark. Yes, totally separate. Not everybody needs a trust. There are three major categories of trusts I do. One is a revocable trust, which we have a low threshold for estate taxes in Massachusetts. We're at $1 million here. And we might be the lowest, and a lot of states like Florida have zero estate taxes. But that's a trust is, I'm going to say this word, trick or technique to avoid, to get our estate, the estate taxes the beneficiaries would pay down to zero is the goal. That's a typical revocable trust, but it has other benefits as well. It avoids probate, to get back to where
Mhm.
that line, that path we were taking earlier. Another kind of trust is really important, a special needs trust. If someone has a disabled beneficiary or someone unable to manage money, the parents, let's say, for example, they'll sign the special needs trust, and then they could leave it unfunded until they die, and their will could say, Johnny Boy, not directly to Johnny Boy, but to his special needs trust, that half goes. So it keeps his Johnny Boy's public benefits safe from loss, because what happens, had many clients on the wrong end of the stick. Johnny Boy, the family of Johnny Boy will come in and say, our mother just died and the father died 10 years earlier, and Johnny Boy inherited half of our mother's estate and he lost all his public benefits because he has more than $2,000, which is a typical program. You have to, so a special needs trust is really important. And the third big category are irrevocable trusts for estate tax reasons and Medicaid planning reasons.
Wow, there's so
Yeah.
much to learn. Karen, your expertise is just remarkable, and I love the way that you simplify the explanation as well. What inspired you then to even focus on elder law and estate planning? Take us back to like how'd you get started?
I know. I started out loving everything about in California in 1978. I was first licensed, and I just wanted to be in the courtroom. So, and I loved everything about the law. So I did everything. And every lawyer will have a different story about that, that answer. For me, what happened is I just slowly said, I'm no longer doing that type of law. I just I had to explore. I had no preconception, and I just started following my heart. I started referring more and more cases to other lawyers and kept what I wanted. And I ended up on estate administration or trust administration, and in elder laws, we said, in estate planning, just because I really enjoyed that work. It's really as simple as, what do I like and what, oh, been there, done that. I'm happy to refer that topic elsewhere.
Oh, I'm so happy for you because I could tell this is
Yeah.
definitely your jam. This
Yeah,
is
it is.
this is your sweet spot. Karen, for folks listening who are in Massachusetts or any areas that you can serve, how
Yeah.
do they find you, connect with you, and learn more?
Okay, thank you. My name is Karen. Because my name is so bland, I like my middle initial, Karen G. Jackson. I'm in Holyoke, Holyoke, Massachusetts, and I serve all of Massachusetts. I'm only licensed to practice in Massachusetts, but I'm happy to help your listeners find an attorney across the country. And my email are my initials, kgj@jlawma.com. And the backside of that is my website, where I have articles on my website to help people.
Terrific. Karen, I really appreciate you taking the time and sharing with my audience today. This has been really eye-opening, and I wish you continued success for you and for all of your clients.
Thank you so much, Mark. It's been a pleasure.
Karen G. Jackson from Western Massachusetts, and this segment's been brought to you by booksgrowbusiness.com. It's the place where busy professionals publish to educate their consumers, to grow their practices, and to leave a legacy. That's all for now. I'm Mark Imperial, and thanks for tuning in.